All right, thank you, Mr. Seaman. Mr. Salagi, are you ready to call your first witness?
You're on defense to call Dr. Nathan Glassman.
Dr. Glassman, if you'd take the stand here, and then raise your right hand.
Do you solemnly swear that the testimony you shall give in the matter now before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You have a seat.
Morning, doctor. Could you state your name and spell the last name for the record?
Yes, name is Nathan, N-A-T-H-A-N, Glassman, G-L-A-S-S-M-A-N.
And you were appointed to examine Mr. Flatoff by this court, correct?
Yes.
And could you give us a brief overview of your qualifications in the area of psychology?
Yeah, I'm a licensed psychologist in the state of Wisconsin. I've been licensed since 1991. I have board certification in clinical psychology and in neuropsychology, and I have extensive continuing education in forensic psychology.
When did you examine Mr. Flatoff?
On January 18th.
And how long did that examination take?
It took approximately 5 hours. There was a morning session and an afternoon session.
Let me back up. Have you been appointed to or hired to do similar evaluations in the past?
Yes.
How many times would you say you've had that experience?
More than 20 or 30. I had my first NGI eval in about 1992.
So over the course of, say, 25 years, seems like maybe about one a year?
One or two, yes. It ebbs and flows.
Is there a standard practice for an NGI evaluation?
In the state of Wisconsin, because of the legal standard, the questions addressed in the way that I've been trained by other board certified practitioners to use the legal standard. So answer, yes, there is a standard of practice.
Sure. And I apologize, I don't think I asked that question well. Is there, in reaching a conclusion on that standard, is there a set of tests or instruments that are routinely used in order to reach that conclusion?
There is no set of tests or instruments that are used. The instrument that I used was designed by a forensic psychologist who's widely known, and that's what I use to guide my analysis. That instrument is designed by Dr. Richard Rogers from Texas.
And if I understand correctly, is that what's referred to in your report? You authored a report, correct?
Yes.
And submitted that to the court?
Yes.
And I apologize, that instrument you were just talking about, is that what's referred to as the Rogers Criminal Responsibility Assessment Scales?
Yes.
Other than meeting with Brian or asking him questions, is there other things that are done in order to prepare such a report?
Yes, there are.
And would you mind giving us an example of, well, would you mind telling us what you did in this instance to prepare for this evaluation or report?
I looked at the criminal complaint. I looked at some of his mental health records. I talked with one of his friends for collateral information. I looked at previous reports that had been authored on the defendant for criminal responsibility. I did an examination for the presence of a mental disorder and a cognitive disorder as well.
What sort of issues did you consider in authoring this report?
Well, the foundation for the assessment is the legal standard for criminal responsibility in the state of Wisconsin. And so that was the basis for my report.
And when you were speaking with Brian, did he raise any concerns about specific symptoms of mental health?
Yes, he did.
And do you recall what those were?
Yes, he said that he had blackouts, times when he couldn't remember what was going on, and he said that in such episodes, his friends told him he did not interact with them, and he did not know why he had these episodes, but thought they were due to a mental disorder.
And would that be correctly referred to as amnesia?
Yes, lack of memory is amnesia.
Were you able to, from your review of prior mental health records or the collateral source, get more detail on these periods of blackouts or amnesia?
Yes.
And what was that detail?
The detail was that Mr. Flatoff had consulted with his doctor and ultimately with a neurologist who examined him and also conducted a brain imaging study, an MRI. The neurologist did not diagnose him with any mental disorders, but noted that the MRI had a small lesion on his brain. It was described as 3 millimeters. That's about 1/10 of an inch. And those are common in middle-aged adults, and it was thought to be non-consequential.
When he spoke with this, brought this concern to his doctors previously, are you aware of chronologically when that was done?
It was within a few months before the instant offense. I believe that may have been in the fall of 2015.
Were there, other than the neurologist, were there other conclusions stated in his medical records concerning those reported blackouts or amnesia?
Not that I recall. There were mention of other symptoms that he had, which potentially could account for him having problems with recall.
Did you consider the possibility of dissociative amnesia?
Yes, I did.
Could you give an explanation of that for the jury, sort of in simple terms, as simple as possible?
Simply stated, dissociative amnesia is forgetting during the course of a highly traumatic event.
And when you considered that issue or that diagnosis, what was your conclusion as far as it applied to Brian?
My conclusion was that if Brian was having problems remembering the event, it was because he had been intoxicated. And it was possible that he actually did remember the event because he gave a statement to police afterward. But either way, I did not believe that lack of memory, if it existed, was due to a mental disorder. It was due to intoxication. It's possible that he could have had some forgetting during that event because it was traumatic. That's a common event for people that are involved in highly emotional and violent situations. So it is possible.
Are you aware of when his statement to the police was given?
My understanding is that it was after he was taken into custody on the morning of the event.
So it's your understanding it was the same day as the event?
That's correct.
And as a mental health professional, how do you generally see dissociative amnesia? Is there usually some period of time before it's established, or is it something that you see established right away after the traumatic event?
My understanding is that dissociative amnesia is quite rare, and I do not know offhand the symptoms and the characterization of dissociative amnesia.
So, if I understood you correctly, you, at this point at least, can't say how long you believe it generally takes for dissociative amnesia to be observed or established after a traumatic event. Is that correct?
That's correct. I'd have to look that up.
Thank you. When you spoke with the friend who was the collateral contact, do you recall the name of the individual you spoke with?
Her name was Eva.
And when you spoke with her, did you talk about, did you ask her about those blackouts or periods of amnesia?
Well, yes, I did.
And did she give you some indication of, or description of them?
She did not. She focused on the events that transpired the night before and the morning of this incident.
Did you ask her if she was aware of those blackouts?
Oh, well, yeah, she did tell me that she was aware.
And you mentioned previously you believed any memory loss that while there may be genuine memory loss, you would attribute that to intoxication, correct?
That's correct.
And how would that be distinguished? How would one distinguish between the two, intoxication versus dissociative amnesia?
Well, in my thinking, the clearest way to distinguish is whether or not there has been evidence that the person has consumed alcohol and whether it seems reasonable that the amount consumed could cause the amnesia.
So, is it a per se test that if someone's had enough alcohol, there's a certain threshold where you would say you no longer consider whether dissociative amnesia is the cause of any memory loss?
In my thinking, it's very difficult to distinguish, and if someone has consumed a large amount of alcohol, say above about 0.25 to about 0.4, depending on the person, because there are individual differences, it is highly likely that a person would not be remembering ongoing events. Yeah.
Sure. Does it factor in to that sort of calculus a prior recorded history of non-alcohol related periods of amnesia?
No.
No. So someone who has expressed or shown symptoms of such amnesia in the past without alcohol intoxication would not be more likely to, in the future, have a repeat of those symptoms?
I can't comment on that because I don't know the scientific basis for the answer to that question.
So I guess then is it fair to say that that was not something that was considered when you were authoring your report?
I did consider whether or not he had amnesia from the blackouts, my analysis was that I could find nothing as far as a mental disorder that would explain the blackouts.
When you say blackouts in the plural, are you referring to those previously expressed as well as on December 5th? Or just on December 5th?
Both.
Is dissociative amnesia a recognized mental disorder? Per, I guess I would say, the DSM-5?
Yes.
And you're, sorry, let me back up. That was, didn't properly ask that question. Are you familiar, and this may seem like a silly question to you, with the DSM-5 or Diagnostic and Statistical Manual, the 5th edition?
Yes, I am.
And could you explain to the jury what that is?
It's known commonly as the DSM. It's in the 5th edition. It's the Diagnostic and Statistical Manual for Mental Disorders. It's widely used in the United States, but to be honest, as a clinical practitioner, I use another system which is called the ICD-10, the International Classification of Diseases, but the DSM-5 is widely used in the United States.
Were there other, moving on from the issue of amnesia, were there other potential mental disorders or diseases that you discussed with Brian?
We talked about his anxiety and depression, talked about his use of substances. He also told me about the traumatic event from years past with his daughter. So those are some of the things that we talked about.
As far as anxiety, did you consider what role that may have had in the events on December 5th?
Yes, I did.
And what was your conclusion on that?
My conclusion was that anxiety was not a factor.
And how did you reach that conclusion?
Brian's, the information that I had from various sources were that Brian was angry that his motorcycle had been stolen. He had reported that to a number of people. He had been thinking about it for quite some time. On the morning in question, he reportedly told Eva that he was going to go there to talk to them about getting his motorcycle back. So based on those, on that information, there was no mention that anxiety was a factor in this situation.
Does anxiety cause, or could it cause someone to fixate on certain situations?
Yes.
Could it cause a delusional belief about situations?
Could.
In your review of Brian's medical records, did you see any instances where that was expressed?
No, I did not.
When you talked to Eva, did she indicate any situations like that to you?
No, she did not.
Could you define the word as it's used in your field of malingering?
Malingering is an intentional exaggeration of symptoms to avoid either responsibility or to achieve a specific goal.
And you had reviewed the report of Dr. William Merrick, correct?
That is correct.
And that issue of malingering, was it raised in his report?
Yes, it was.
Were you able to reach an independent conclusion on the issue of malingering?
Yes, I was.
What was your conclusion?
Well, my conclusion, based on my evaluation with Mr. Flatoff, was that I did not see evidence of malingering of his cognitive or cognitive functioning with me. I felt that his characterization of his current emotional status, which I tested, was not accurate, but it wasn't to the degree that I could characterize it as malingering. And I did not address whether or not he was malingering his amnesia for the events, because I did not believe that that was a relevant factor, because the assertion that he could not remember was not due to a mental disorder.
And I'm sorry, I'm going to back up a little bit. In part of your question, you mentioned an evaluation of his emotional state.
That's correct.
And you didn't believe that was congruent with what he was telling you?
There were two ways that I gathered information about his emotional state. In what he told me, I believed was accurate. In what he indicated by responding to a written test, I believed was inaccurate.
And were you able to reach a conclusion on the cause of that inaccuracy?
Let me refresh my memory here. Take a look at my notes.
Are you referring to your notes or a report that was submitted to the court?
My report. And, you know, I did come to a conclusion that his report was not valid.
And did you reach any conclusion as to why it was not valid?
It was not valid because, taken at face value, the symptoms that he reported on the test, I would be faced with a man who was psychotic, not in touch with reality, and not able to act in a normal way, and severely depressed. I didn't see that. That was not consistent with his presentation in the 5 hours that I spent with him.
And if I understood correctly, it also wasn't consistent with what he verbally expressed to you in terms of his emotional state?
What he verbally expressed was that he was very worried about his case, but that he wanted to go to court and he wanted to have his days in court, tell his story, and he was reconciled to that.
Did you address that inconsistency with him?
No, I did not.
And Brian knew the purpose for your evaluation, correct?
That is correct.
That you would be authoring a report and submitting it to the court, the district attorney, and to, at the time, himself.
That's correct.
Apologize, just one moment. So you have a copy of your report with you there?
Yes, I do.
On page 6, what's marked as page 6 of your report, under the heading of regarding the presence of a mental disease or defect, could you, the first bullet, or the first numerical point, is also concerning malingering, correct?
Yes, it is.
And in there, it says that the defendant was not likely exaggerating his mental or emotional symptoms regarding the instant offenses, correct?
That is correct.
Could you explain that to us? I guess I'm a... Could you explain that to us?
Yeah. So that statement is in consideration of his state of mind at the time that the incident took place. He did not assert to me that he was having anxiety, depression, or other mental disturbances. He did assert that he could not remember the events. He wasn't saying that he couldn't control his behavior or that he wasn't unaware that what he was doing was wrong. He just was asserting that he could not remember the events. So that's what that refers to in considering of malingering at the time of the offense.
And did he tell you how long of a period of time that that amnesia in that particular instance, what the duration was?
Yes, he did. He said he could not remember the morning, and for a time after the event, he said he did not remember. So it basically was for the time of the event and longer, a bit before and a bit after.
So specifically, that a lapse or gap in his memory began the morning of December 5th?
That's correct.
You mentioned the other, I guess I would say collateral sources that you reviewed. Was that review done prior to the evaluation or subsequent to it?
Some was reviewed prior and some was reviewed subsequent to it.
Did you review Dr. Merritt's report prior to the evaluation or subsequent to it?
I reviewed small parts of it, just looking at the background and history of the defendant.
And did you review the remainder of it then subsequent to the evaluation?
That's correct, I did.
Do you recall if Brian expressed to Dr. Merritt the length of his amnesia, memory loss?
I do not recall offhand. No, I don't recall offhand. I'd have to look at his report.
Was it your understanding that Brian felt justified in his behavior on December 5th?
Yes.
And could you elaborate on that?
He had reported to me, and there was other evidence that he believed that his motorcycle had been stolen, and so he wanted to go get that motorcycle back.
Is that all that he said, or concerning that issue?
That's my understanding about the things that he had said before this incident, and that Eva had told me when I talked with her that he was going to go and talk to people at the motorcycle shop about getting his motorcycle back.
And did she tell you if this had been a long-running issue or concern of Brian's?
Her comment was that he had had the police look into it, and that he had recently been told that by the police that they were not going to look into it anymore. So it had been going on for some time.
And did she tell you how Brian reacted to that information?
Not that I recall.
Is it possible that someone feels justified in their behavior due to delusional thinking?
Yes, that certainly is possible.
If you identified delusional thoughts, how would you, let me rephrase that, I apologize. How would you define delusional thinking?
As I would define delusional thinking as thinking that is not based in reality.
Is it necessarily something that's based in unreality or something that's far removed from reality?
I think it would depend, but delusional beliefs, my understanding is that in general they're about something that is not true, such as a person believing that other people are out to hurt him or another way harm him, or maybe a person believing that they're infected with germs when that is not true.
Did you observe any indication of delusional thinking, either in the medical records, speaking with Brian or Eva?
No, I did not.
Concerning the motorcycle, did Brian feel that he had been wronged in that issue?
He felt that the motorcycle had been stolen. He told me he thought that the title had been forged. So, yeah, he thought he had been wronged, if that could be wronged.
Could such an opinion rise to the level of delusional thinking?
It could.
What would keep it from doing so?
I don't know. Treatment, medication, sometimes people are dissuaded from their delusional beliefs by evidence. There could be various ways that that they would not have serious delusional beliefs.
Did you ask, or in your conversation with Eva, was it discussed whether she also agreed with Brian's version of events concerning his motorcycle?
No, we did not discuss that.
Do you recall how far back in time the medical records you reviewed, how far back in time they went?
Offhand, I don't. They were from the year in question, 2015. They might have gone a bit earlier, but I don't recall.
And I apologize for coming back to this after a little while, but if I understand correctly, your recollection was that the blackouts or amnesia was first presented to healthcare professionals in the fall of 2015, is that right?
Approximately, yes.
And did you consider the diagnosis of post-traumatic stress disorder?
Yes, I did.
And what was your conclusion on that issue?
That based on what Mr. Flatoff told me, he had had a highly traumatic experience some years ago. It had been upsetting to him, and he had basically recovered from it. And as far as I could discern, that post-traumatic stress disorder was not a factor in his thinking or behavior in the events in question.
And how did you reach that conclusion?
In two ways. One is based on the report of things that Brian told me about the situation which led to him feeling stressed, and that it had happened back in about 2002. And the other being that there were no complaints of symptoms during the time of this situation in which there was any talk that he was feeling traumatized or was thinking about those events that were the source of his trauma.
based on his report to you?
Based on his report and based on the accounts of the situation that I was able to review by officers and witnesses that were there.
He didn't report symptoms consistent with suffering from post-traumatic stress disorder?
No.
But he also told you that he couldn't remember the incidents of December 5th.
That's correct.
Did you find any basis for a diagnosis of post-traumatic stress disorder in his medical records?
He has PTSD as a previous diagnosis. So yes, I did.
So am I understanding, are you saying that that's an invalid diagnosis or no longer applicable?
I'm saying that, as I noted in my report, he has a history of that diagnosis, and post-traumatic stress disorder is one in which symptoms can wax and wane. At the time that I examined him, I did not see symptoms of post-traumatic stress disorder, and on my examination of the facts that were available to me about this event, I did not see the presence of symptoms of post-traumatic stress disorder. But he does have that disorder by history, and that's how I've noted it in my report.
And I apologize, I just had one last line of questioning and then I'll be through. Circling back around to alcohol intoxication. If I understood what you said correctly, is it accurate that as a clinician you look to perhaps the most likely cause first in assessing a diagnosis?
Yeah, I would say that's an accurate characterization. In medicine, there's an expression: if you hear hoofbeats in the street, you wouldn't automatically assume that it was a zebra.
Although it could be, reason says otherwise. Is that right?
It's possible.
Sure. And so, while it could be dissociative amnesia, from your perspective, in your position, is that it is more likely to have been caused by alcohol intoxication.
Objection leading, mischaracterization of the evidence.
Your Honor, I'm asking him if that is correct. It's a correct restatement of his position. You can certainly correct me if that's...
I'll overrule the objection.
My feeling is, and my opinion is, that it was more likely that it was alcohol intoxication than other causes.
No further questions, Your Honor.
All right, thank you. Mr. Seaman?
Thank you, Your Honor. Doctor, I've shown you what's been marked as State's Exhibit number 42. Can you identify what that exhibit is?
This is a copy of the report that I authored in this case.
And does that exhibit appear to be a complete and accurate copy of the report that you authored and submitted to the court in this case?
Yes, it does.
And just so it's on record, the State would move Exhibit 42 in the evidence.
Any objection?
No, Your Honor.
We'll take that so you don't accidentally walk away with it. Thank you.
Now, Doctor, you just concluded your testimony that the really only underlying medical factor that, or psychiatric factor that resulted in the defendant going to Eagle Nation on December 5th, 2015 and committing these crimes is because he was drunk, correct?
I'm saying that that looked like it was the reason that he was having problems remembering. I don't know about the connection of his being drunk to why he did those crimes, and whether that was causative.
Well, you also diagnosed him with antisocial personality disorder, correct?
That is correct.
And what is antisocial personality disorder?
Antisocial personality disorder is a long-standing pattern of behavior which involves breaking norms of behavior, breaking laws, and in other ways not respecting the rights or property of others.
And you're aware that antisocial personality disorder cannot legally be a basis for finding a mental disease, and as a result of the mental disease, the defendant should not be responsible for criminal conduct, correct?
Objection, Your Honor. I believe it's a mischaracterization of the law.
All right, well, overruled, you can answer that.
Yeah, my understanding is that repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect.
So antisocial personality disorder, under the law, for the basis of your finding, cannot be the basis of a mental disease or a defect for criminal responsibility, correct?
Yes, I would agree with that.
And you diagnosed the defendant with antisocial personality disorder in part because of his significant criminal record, correct?
That is correct.
And what was, what is it about the defendant's criminal record or aspects of his criminal record that led you to that diagnosis of antisocial personality disorder?
It was long-standing. It began when he was a teenager, which is one of the criteria that it begins rather early in life, and that it involved behaviors such as burglary and robbery and so on. So those were the things that formed the basis of that diagnosis.
And then you're also aware from your review of the case that the the defendant's blood alcohol concentration later that day, after he was at the hospital, was determined to still be 0.12, correct?
That is correct.
And so you add that level of intoxication with someone with an antisocial personality disorder, and these types of crime is a very possible outcome, correct?
It is possible.
And throughout that extensive criminal history of the defendant, you're aware that he has never been found not responsible for mental disease or defect, correct?
That's my understanding, yes, that's correct.
And the other diagnoses that you gave in your report, besides antisocial personality disorder, were alcohol dependence, cannabis use, and other drug abuse. Were three additional ones, correct?
That is correct, yes.
And then you also diagnose depression, panic disorder, which is what we've been calling anxiety disorder here, correct?
Yeah, panic disorder does include an aspect of anxiety, yes.
And then post-traumatic stress disorder.
That's correct.
And you opine that regarding the depression, panic disorder, and post-traumatic stress disorder, that the defendant displayed no symptoms of those three mental disorders on December 5th, 2015, correct?
Yes, that's correct.
And that it's your opinion that the defendant's actions on December 5th, 2015 were not the product of those diagnoses, correct?
That's correct.
And in fact, would it be fair to say that for the purposes of this report, that the depression, the panic or anxiety disorder, the post-traumatic stress disorder would only be relevant diagnoses as mental diseases if he was, for these purposes, if he was actually displaying symptoms on the date of the event?
Yes, that's correct.
Which he was not, correct?
I didn't have evidence that he had those symptoms.
Now, in fact, you opined that the defendant on the date of the offense could appreciate the wrongfulness of his conduct, correct?
I believe that it was reasonable that, given his background, that he would understand that the things that were happening there were wrong.
And not only just based on the background, but also by statements he made to the police afterwards, such as the comment he made that he hoped nobody had died, correct?
Yes, that's correct.
And with the evidence that the defendant essentially snuck out of Ava Kronsky's house with a firearm while she was sleeping, be demonstrative of the defendant appreciating the wrongfulness of what he was about to do?
Not necessarily.
Well, if he was broadcasting what he was about to do, that's right there. Somebody hiding the conduct that he was criminally engaging in your opinion, is not evidence appreciating the wrongfulness of it?
Well, my understanding is that Eva was sleeping, so he got the gun when she was asleep.
So you have no independent knowledge that he intentionally snuck out with the gun?
No.
And you opine that the defendant was able to conform his conduct to the requirements of the law that day, correct?
That is correct.
And that's based on his going down to Eagle Nation on that day was the product of his wanting the bike back, not the product of a mental disease or defect, correct?
That is correct.
And he was very goal-orientated in getting, in trying to get that bike back, correct?
That is correct.
And that his goals and the steps he took to achieve those goals, to get the bike back, to kill Vance Dalton, was based in reality, correct?
Yes.
And the fact that he didn't go down there the night before, or earlier that morning when he was talking with David Kransky about it, the fact that he waited for whatever reason till sometime later when she was sleeping shows that he was able to conform his conduct to the requirements of the law, correct?
I don't think that there's a connection there.
Based on the factors we just talked about, though, you opine he was able to conform his conduct to the requirements of the law that day, correct?
Yes.
And he was able to appreciate the wrongfulness of his conduct, correct?
Yes.
And in reviewing the other reports, prior to submitting your report, you reviewed the report of Dr. Niess, N-I-E-S-S, correct?
That is correct.
And that was from the Outagamie felony case that preceded this case.
That's correct.
And that doctor opined that the defendant's responsibility was responsible in that case. His crime wasn't the product of mental disease or defect, correct?
That is correct.
And then Dr. Merrick's report was also done in connection to this case that you filed a report on, correct?
That's correct.
And that was done in March of 2016?
Yes.
And Dr. Merrick opined that the defendant's conduct on December 5th, 2015 was not the product of mental disease or defect, correct?
Yes, that's correct.
Now, regarding speaking, when you spoke with Ava Lawson-Kronsky, did she ever make any statement to you regarding an opinion of the defendant having multiple personality disorder?
No, she did not.
And you saw no such evidence of any type of disorder, correct?
No, I did not.
Now, if the defendant was under some type of legal guardianship, like a Chapter 51 or a Chapter 55 or whatnot, that would have been something that would have been typically within the medical records, correct? Psychiatric records?
I would assume that there would be mention of that in records, yes.
And there was no such mention of any type of guardianship of the defendant that you were able to see, correct?
That is correct.
During the course of this evaluation, that you could not remember the events of December 5th, 2015, that morning?
Yes, that was my understanding, that he could not remember the events of that morning.
And that was based on, that's his self-report to you, correct? That's what he told you?
Yes, that's what he did tell me.
And yet you were aware of the evidence that he reported to the police, he's relayed in the past that he recalled the events that morning, correct?
Yes, I read the police report.
But of course, you testified that when the defendant spoke with you regarding this evaluation, he knew it was going to be the basis of the special plea in this case, his insanity plea, correct?
That's correct.
And those lesions, or that one lesion, that one small lesion that you testified to regarding, that was found in the MRI of the defendant's brain, you testified that that was a common thing to see in an MRI scan of a middle-aged male, correct?
That is correct.
And that was not anything that will cause any type of impairment?
It's possible it could cause an impairment, but often they cause no impairment.
And you saw no evidence that this small common lesion caused any type of impairment in this case, correct?
That is correct.
Based on you're seeing no evidence that the defendant was under any of the symptoms of depression, anxiety, or post-traumatic stress disorder on the morning of December 5th, 2015, then would it not be your opinion, based on to a level of reasonable degree of medical and scientific certainty, that on the morning of December 5th, 2015, the defendant was only under the influence of an intoxicant with having antisocial personality disorder?
Yes.
And it's your opinion to a reasonable degree of medical and scientific certainty that on the date of December 5th, 2015, the defendant could conform his requirements to could conform his conduct to the requirements of the law?
Yes.
And it's your opinion that on that same date, to a reasonable degree of medical and scientific certainty, that the defendant could appreciate the wrongfulness of this conduct?
Yes.
And you see the Brian Flatoff in court here today, who you met with for 5 hours and performed these evaluations on?
Yes, I do.
And he's the person seated 2 persons to my left?
Yes.
I'd ask the record to reflect the witness to identify the defendant. No further questions.
Mr. Slodgy?
As far as identification, or?
Yes.
No objection,
You
right?
will. All right. Can we redirect?
Yes, just briefly. Doc, are you, in your practice, are you familiar with the term self-medication or self-medicate?
Yes. Yes, I am.
And what does that mean to you?
Well, it's something that I hear when people tell me that they're drinking or using drugs, and they say that it's to try to reduce symptoms of anxiety, depression, or other symptoms.
In your review of Brian's medical records, did you see any evidence of that?
Well, It's possible that he's, quote, self-medicating. My problem with that as a term is that often when people talk about using a substance to self-medicate, the imbalance, it causes many more problems than it solves. And so while it's possible that Mr. Flatoff's uses of alcohol or other drugs was related to his symptoms of depression or anxiety or post-traumatic stress, those uses often cause more problems than they solve. So it's possible that he was self-medicating.
Did you see any indication of that in his medical records?
I did not see anything that I recall about self-medication.
Did he discuss the effectiveness of medications with his doctors, from your recollection?
I'm sure he did.
Did he raise concerns about the effectiveness versus the effect as he viewed it? And I think I understand your point as far as whether it indeed is beneficial, but as far as he viewed the benefits between prescribed medication and alcohol in terms of relieving symptoms.
I have recollection that he did discuss that with his doctor and felt like some of the medications that were prescribed were not effective.
If someone were unable to conform their conduct to the requirements of law, as opposed to not knowing whether their conduct is wrong or not, what would you be looking for in terms of characteristics of that person?
Well, not conforming conduct really speaks to volition or control. Knowing whether conduct is right or wrong speaks to knowledge. In considering whether somebody can conform their conduct, the considerations are whether they're based in reality, whether they're interacting normally, whether they seem to be able to start, stop, or switch behavior. Those are things that relate to volition. In knowledge, having a general knowledge that something is correct or not is more general knowledge.
So, is it possible, hypothetically, that someone could be goal-oriented towards a certain outcome, but unable to conform their conduct with the requirements of law?
It's possible.
In terms of likelihood, is it something that you rephrase that? I have no further questions.
Nothing further. Thank you, Doctor.
All right, Dr. Glassman, thank you for your time today.
Thank you.
Is he released from his subpoena?
Yes, Your Honor.
Yes.
Mr. Slodgy?
You're on a defensive call, Eva Lawson-Cranston.
All right, and if the jurors want to stretch at this point, feel free to stand. Okay, ma'am, you can step forward. Take the stand and raise your right hand.
You solemnly swear that the testimony you shall give in the matter now before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. You may have a seat.
Good morning. Is it if I just call you Ms. Kransky, is that okay?
Sure.
And just to reacquaint the jury, as you previously testified, could you describe how, well, if you know Brian Flatoff, and if so, how?
I know him, like I said earlier, for many, many years as one of the best and oldest tattooist in the area, family friends. And then we had a personal relationship starting in late July 2012.
And how long did that relationship last?
Well, we were together up until July 25th, 2015. And for 3 months, I wasn't with him. Vance and Samantha.
Sure.
Anyway, and after 3 months, almost to the date, maybe to the date, in October, I resumed care and...
Your relationship, or...
Yes.
Focusing your attention to 2015, are you familiar with medical care that Brian received?
Yes.
And how are you familiar with that?
I scheduled and took him to all of his appointments. I spoke with all of his physicians, and together we would explain things to him.
And were you present during these appointments?
Yes.
With the doctors or in the room?
Yes, always.
And do you recall taking him to the doctor in May of 2015?
I'm quite sure I did. I took him to many, many appointments.
Do you recall what symptoms he had expressed at that time?
In the beginning, I couldn't get him to see a doctor. It wasn't up until he started having severe chest pains that he agreed. But he was very anxious, just showing odd behaviors, symptoms that I'm familiar with, but since I'm not licensed in any medical field, I just knew he needed care. He needed a physician. I tried to get him into a psychiatric doctor, but we had to wait on a list because of Obamacare.
And do you recall when his name was put on that waiting list?
It was either October or November of 2014, and we finally got his first appointment in November, I believe, of 2015.
And during that period of time, did you recall ever seeing, did Brian ever express to you concerns about feeling like he lost periods of time or wasn't aware of what was going on?
Yes, almost daily. He would yell my name. He always calls me Eve. Many times throughout the day. Eve, where are you? Come here. That he would ask me, is this the time? Is today Tuesday? Sometimes he didn't know the year. He would hole up in the back office and not want to come out. 4 months went by and he didn't realize it. He popped up one day like everything was normal and just went with the flow. I mean, everybody, his family, friends, customers, everybody knew that Brian, there was just something about Brian. He's not.
Sure. And when you took him to the doctor, do you know if he relayed those issues to the doctor?
At first he was afraid because he didn't want to be labeled as something other than a man. He was raised to believe that men don't cry, they don't go to the doctor, you just deal with it. So I finally had to make him tell the doctors and his therapist the truth.
And at that time, when he did tell his doctors, was he in any legal trouble?
Not at that time, no.
Was he going through any sort of other court process, maybe lawsuits, divorce, anything?
We had a lawsuit with the previous landlord for overcharging us for utilities.
And I apologize if my question was inadvertently too broad. Was there anything going on that could you see any motive for him making those claims if they were not true, from your perspective?
No. He always told me the truth.
So there was nothing you could see that he was avoiding at that time by claiming to have such symptoms?
No.
Or nothing he was gaining from you, as far as you could tell?
No, he didn't want to be labeled inadequate in any way.
And it was, do you recall when he got in trouble for his OWI?
Yes, I do.
And approximately when was that?
I believe it was August, middle of August, 2015.
And so, from your testimony, is it correct, he'd already been going to the doctor approximately 9 months at that point?
Yes.
And bringing up those symptoms of losing time, things like that, is that correct?
Yes, anxiety, panic, losing a lot of time, confusion, a lot of confusion.
When those, you mentioned that you saw multiple instances of Brian not really being oriented or aware of what was going on around him. Was he, to your knowledge, consuming alcohol at that time?
No, not always. Very rare. I wouldn't allow him to drink. So if he did drink, it would exacerbate it if he drank too much. But no, I made him be sober with me, and he was with me almost 24/7.
So is it fair to say that there were times when you noted those instances or those occurrences happening where he was both drinking and not drinking? Is that
right? Yes.
Did it seem, from your perspective, to differ between whether he was drinking or not?
No.
Either in terms of frequency or in terms of severity?
If he was extremely intoxicated, he may be goofy and silly, or if something or someone was bothering him, he might get hostile, but not dangerous. And that was it. It just added to his confusion. Friends and family would tell you.
Just a moment. Ms. Cranston, you mentioned sort of functioning in a role of
Guardian.
okay, not court appointed though, correct?
No.
Did you in any way assist Brian in managing his medical records?
Yes.
Okay. And in what way?
I kept very close, kept everything together, and he was very good at that. He's a very organized person.
So you assisted him in managing or maintaining his medical records?
Correct.
I'm going to show you what's been marked as Defense Exhibit E. Does this look familiar to you?
Yes.
And could you tell the jury what it is, do you believe?
This?
Yes.
It's Dr. Lather Kapala's notes about his history and present illness.
About a visit?
Yes.
Okay. And what's the date of that?
It's dated December 17, 2015.
I apologize.
Oh, here. 5/4/2015.
And were you present at that time?
Yes.
And you were involved in that visit?
Yes.
Do you recall at that time Brian speaking to the doctor about concerns?
Yes.
What specific concerns did he express to the doctor?
He was extremely concerned about the chest pains, the tingling and numbness in his hand, and the blackouts, losing time.
And similar to what we've already talked about?
Correct.
Is that correct? I have nothing further.
Mr. Seaman?
Now, Ms. Kransky, you testified that you're the defendant's sort of a guardian, correct?
Correct.
That's a self-appointed guardian?
Well, two of his doctors recommended that he stay in my care.
You're not a court-appointed guardian, correct?
Not by court. I was
Yeah.
going to go through that process, but didn't yet.
And you say the doctors, you just said that the doctors recommended that he stay in your care.
Yes.
Do you think the doctors knew you had a house full of guns?
It made no matter. Brian didn't like guns. He never touched them. He'd been to my home.
I'm showing you what's
many
been marked
times.
as State's Exhibit 48. In fact, that's the case that he took the MAC-10 style pistol from your house, correct?
It looks to be yes.
In fact, that's another gun lying underneath it, correct?
I see the stock. It could have been a pellet gun. It would have to have been a pellet gun. Oh no, that's I see the finish on it now. It's an old rifle of sorts that doesn't work. It was going to be basically a wall piece, or just gotten rid of.
I'm showing you what's been marked as State's Exhibit number 49. That's where the case was located that morning after he took the gun, correct?
Yes. Sorry for the mess.
Yeah, in fact, and this is your living room, Ms. Kransky?
No, this would be the dining room.
That's your dining room.
Was, yes.
And it's your opinion that the doctors recommended you be his guardian?
He didn't stay with me in my home.
In fact, it was at your house where he got a bottle of tequila on December 4th, correct?
It was a bottle of mezcal. It was a gag gift out in my garage. It had been there for approximately 5 years. He had cleaned out the garage and made a workbench and a place to do that. He obviously came across that bottle, and I was unaware of it.
In fact, you gave a statement on December 5th, 2015 to Detective Craig Quick, correct?
I talked with him, but I never gave him a statement.
And you told him regarding the motorcycle that there was a motorcycle issue in which an individual you identified as Vance from Eagle Nation Motorcycles had been involved with several other people in stealing Brian Flatoff's motorcycle, correct? So you were of the opinion that they had stolen the motorcycle, correct?
Yeah, I know they did.
Nothing further.
Mr. Slodgy?
Notary Director.
Okay, ma'am, I'll take those exhibits. And is she excused from her subpoena?
Yes.
The state would move those two exhibits into evidence, Your Honor, I forget the numbers.
Any objections receiving 48 and 49?
No.
They'll be received, and ma'am, you're excused. Thank you.
And I believe at this time the defense will move Exhibit E. Best to do so.
State would object, that's a medical report with no foundation whatsoever.
All right, we'll receive it, and obviously whether it goes to the jury and could be referencing further, we can take care of that issue outside the jury. All right, let's take our morning recess.
All rise.
We may be seated. All right, outside the presence of the jury, Mr. Slodgy, do you have any other witnesses?
No, Your Honor. I was just about to arrest.
Oh, okay. And Mr. Seaman, are you planning on calling any witnesses?
No, Your Honor.
All right, did you have a chance to look at the jury instructions?
Yes, Your Honor.
All right.
Your Honor, if I may,
Yeah.
before we get there, the state moves for a directed verdict in this case. This is a case that is clearly supported by law. I will provide a copy to the defense, copy of relevant case law to the court. This is a case where, in light of the evidence presented, no reasonable jury could conclude that the defendant has met his burden. Under the case law, specifically State v. Megan, this case, looking at the facts of the case, this is a statutory hearing. This is not a constitutional hearing. What's of evidence here in this record is that there's been 2 expert evaluations regarding the insanity issue in this case, and both experts have opined that the defendant does not meet the statutory requirements. There was also, of record in this case, another NGI evaluation prior to this offense, which came to the same conclusion. So we already have, of record, 2 NGI evaluations from 2 experts. One, apparently, I have to assume, I haven't had a copy of it, I've been told it's been emailed to us last week, but that was testified by the expert here today. Dr. Merrick came to the opinion of malingering as well as no mental disease or defect, or that this conduct wasn't the product of the same. At the testimony here today, the expert opinion is that the only thing that the defendant was regarding the mental culpability, that he was under the influence of an intoxicant at the time of the offense, while being diagnosed with antisocial personality disorder, which is, by law, cannot be a basis for the special plea. There's no mental disease, no mental defect. The expert testified he was able to conform in his opinion and able to appreciate. The only thing offered to counter the expert evidence in this case is the lay witness, Ava Krosky, who the record does establish is biased. She does have a personal relationship with the defendant. It's relevant to note that based on, she couldn't give any diagnosis, but she observed things, and she testified that drinking exasperated those conditions. She testified the defendant would get hostile when drunk. She claimed to be some type of doctor-recommended guardian, but I think that's been debunked.
Ma'am, you don't just start yelling out in court. Do you understand that?
It's documented.
Mr. Seaman, continue.
That's been debunked as well. So when the court looks at the case law regarding directed verdicts in these cases, has been provided to the court, there's essentially no error when being presented with this level of expert test. Basically, there's no error if the defendant testifies on his own and is countered by a state expert. A directed verdict is appropriate. In this case, it wasn't even the defendant, it was somebody else who testified. And she could not, there's no way a jury, legally, under the law, could reach the lawful verdict for this statutory hearing in light of the expert testimony that's been provided. And that's established with the Supreme Court precedent I provided to the court. So the state requests that the court at this time end this, take this from the jury. The record is, I think, more than sufficient to establish that this is a proper case for directed verdict.
Mr. Sludge.
Well, I suppose first of all I would say that I did send the report to Attorney Stephen Friday, March 2nd. I apologize if that wasn't received, but my understanding was I received any error or other indication my email did not go through with all of those attachments, nor did I receive any additional requests that they be made available. As far as the directed verdict, I have not had an opportunity to read the case that was just presented to me. My understanding is, though, one of the the holdings of this case and others on this issue. And I apologize, I was just looking for headnote 19, which I believe corresponds to the printed page 12. Where it says in paragraph 41, although expert testimony may be helpful to a defendant in the responsibility phase of the trial, quote, a favorable expert opinion is not an indispensable prerequisite to a finding of mental disease or defect. So, while I certainly would not, I suppose, for a large part, dispute the state's characterization of expert testimony, I don't believe that the lack of a favorable expert opinion is fatal to a proposition of NGI, and that there has been, I believe the record does establish that there is sufficient evidence where a jury could conclude that Mr. Flatoff, was suffering from a mental disease or defect, and they could conclude whether that mental disease or defect caused him to either be unable to appreciate the wrongfulness of his conduct or an inability to conform with it. It is an appropriate jury question given the facts and the evidence and the issues in controversy. While I understand the experts' positions, that's not a requirement.
I did review this case preparing for today, so I'm familiar with it, and it does indicate that court may direct a verdict against the defendant on issues of mental responsibility if the defendant fails to present sufficient evidence to create a jury question when evidence viewed in light most favorable to the defendant. So, that is the standard. I got to review it in the evidence in light most favorable to the defendant. I mean, even, I guess, when Mr. Seaman started talking about the possible credibility issues raised by Ms. Conkey, caused me to reflect that, yeah, there might be credibility issues, but whenever there are credibility issues, that's an issue for a trier of fact to sort through and figure out. And in this case, Ms. Kronsky did present some evidence to indicate that there were blackouts and losses of time, and a reasonable jury could possibly accept that evidence as supporting their cause of action here, which is the NGI plea. So the court is going to deny the state's motion for a directed verdict at this time, and we'll let the jury determine this issue. I'll find there is enough evidence presented to allow them to make that decision. As to the jury instructions, did you have a chance to look at them?
Yes, Your Honor.
Mr. Seaman?
Yes, Your Honor.
All right. So let's go through them. And just like before, if you don't have any objections, I'll just state the number and the title. Unless you have no objections, you don't need to speak up. So instruction 100, opening instructions. 605, instructions on issue of the defendant's criminal responsibility. Specifically on page 3, I guess we have to make some decisions of what should be read to the jurors there. That first one, temporary passion or frenzy prompted by revenge, hatred, jealousy. Is the state asking for that?
Yes, Your Honor.
The second one, an abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect.
That's a record.
Voluntary intoxication does not constitute a mental disease or defect. That was supported by the record. The temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute mental health. That seems to be supported by the record. As well as the chronic use of drugs or alcohol may produce a condition that constitutes a mental disease or defect if the condition has become permanent. All right, so we want all of them in, Mr. Seaman?
Yes, Your Honor.
Mr. Slodgy?
No objection.
Okay. All right, so page 5 then, 640, mental disease or defect, expert opinion testimony. 160, closing argument. 460, closing instructions. The only thing that seems to be lacking, I'll have to, I was looking at, is the instruction about the 5-6 verdict and the dissenting jurors. So that must be, I was looking at the civil instructions, that might be 180 or 190 or 191. So I'll find that instruction and put that in as well. Any objections?
No, Your Honor.
I believe I might have that, Your Honor. I just have the burden of proof is 200 in civil, I don't have that.
Okay. But the burden of proof, I think, is discussed right in 605.
It is.
Okay, so I'll find the civil instructions that talk about the 5-6 verdict and put that in at the end. And then once that's compiled, I'll send that out for your review. And then just let me know if that's acceptable. The instructions are a bit light. It doesn't have credibility, but that was all covered in the phase 1. I don't know, is there any instructions from phase 1 that you want included in this instruction?
No, Your Honor.
No.
Okay. And then special verdict form. Mr. Seaman, you have a chance to review that?
I did, Judge.
And then how does that look?
No objection.
Mr. Slodgy? With the special verdict form?
That's fine.
All right, I will make these changes and send them out for your review, and we'll reconvene at 11 o'clock and go right to instructions. We'll let you rest in front of the jury, go right into instructions, and then right into closing arguments. All right?
Thank you.